do want to say a couple words in advance, though, that this is strictly a training session for the benefit of the council members and planning commission members on land use issues when they potentially become quasi-judicial. So there will not be an opportunity for public comment tonight. Again, we're not taking up any city issues. It's purely a training session for both planning commission and council. With that, I'll turn it over to City Attorney Bob Sterling.
Thank you, Mr. Mayor, and good evening, everyone. Thanks for coming out on this beautiful night to talk about what is usually puts our colleagues to sleep, and that is land use decision making. A little context here. There have been a number of major land use decisions surrounding Snoqualmie Ridge 1 and 2, and those were many years ago, and it's been a long time since really big projects and decisions came in front of either of these two bodies. And I think during the course of some of the issues that came up just over the past year, there were a number of questions about what are the rules that apply to land use decision making by the city, and what is quasi-judicial, and what's the appropriate role of the planning commission versus the city council, and a host of other issues. And so following on that, we have done some training with the planning commission and council on process, and Ann McFarland with Jurassic Parliament was here, and we did some procedural training. This is the substantive piece to talk about what rules apply in land use decision making and who applies them and when. And we're fortunate to have the assistance tonight of Mike Walter from Keating, Buckland, and McCormick. Mike's a shareholder in that firm, and which is the one of the regional firms appointed by the city's insurance risk pool, Washington City's insurance authority, to handle cases arising out of lawsuits against cities. That's what they do, that's what they specialize in, and Mike focuses his practice on land use cases, constitutional and environmental cases. So if there's been a case in the last 15 or 20 years involving a suit against a city arising out of a land use case, Mike's probably handled it or been involved in it in some way. He holds not one but two Bachelor of Arts degrees from the University of Washington, his law degree from the Seattle University. He speaks regularly to the Association of Municipal Attorneys, the Hearing Examiners Conference, the Washington Association of Planners, and a number of other organizations. He is the guy to talk to you about this, and so without further ado, I'm going to turn it over to Mike to talk about best practices for land use decision making.
Well, let's see, probably not, but as Bob will attest, and those that know me, I don't need a microphone or an amplifier. I've never been told by anyone that they couldn't hear me. But if that happens tonight, raise your hand and let me know you can't hear me, and I'll speak up. I've got a pretty loud booming voice, and I tend to project, so part of that will try to be to keep everybody energized tonight. Bob and Mr. Mayor and council members and planning commissioners and public, thank you all for inviting me out here tonight. As Bob indicated, I and my law firm literally specialize in representing local government in all sorts of litigation. We also provide training for local government on all aspects of governance, and my specialty, or emphasis I should say, is land use and environmental and permitting types of matters. I've been doing it for, I'm embarrassed to say, about 20 some years. That's aging me, but about 25 years or so. And Bob's right, I get involved in a lot of land use cases. Fortunately for me, I guess, the last few years there have been a couple of just really nasty, ugly land use cases that I was not involved in, so I don't have to take any blame for those. But I'm going to give you some examples as I go through tonight about land use decision making. And my goal tonight is to do a couple of things. Number one, tell you about the different types of decision making for land use matters. And you're going to find out that my comments are really tailored to both planning commissioners and council members, as well as staff. So take what I'm telling you tonight as applicable to all of your decision making and work that you do. The other thing I want to do is identify kind of high risk types of land use decision making, so you have an idea what to watch out for when you're involved in making decisions on land use matters, taking land use actions, so that you can kind of do issue spotting and know what steps to take to help make a defensible decision. And then the other part of this is basically to give you substantive rules and a lot of tips to help you make the right decision. When I say the right decision, I'm not talking about making the decision that's going to make you popular or curry favor with everybody in town, but the right decision means one that is done pursuant to the legal standards that are in place for decision making, and one that would be legally defensible if we had to deal with it or defend it in court. So those are some of the goals that I'm going to be, or things I'm going to try to cover tonight for you. I've got a lot of material here. I'm going to, some of it maybe zip through a little bit quicker. I love starting off with this quote. It's a great quote. People have seen some of my presentations and seen me use it before, but it really hits the nail on the head. People are going, well, why are we getting this training? This quote kind of tells it all, and it's not focused on the city of Snoqualmie by any means. And by the way, I want to make it clear, all the cities I do work for, 80-some, get request training like this several times a year. So this is not unique because Snoqualmie is doing something wrong, not at all. It's actually good practice, good risk management, and it's just good to keep up on the law. I was talking to somebody when I came in tonight that getting training like this is like going to school. It's like you never want to stop learning, and that's what the training's all about, particularly since, as Bob will attest, the law in this area changes frequently, and it's pretty confusing even for practitioners that specialize in it. So what's the big deal with land use mistakes? If we make a mistake, can't we just fix it? White it out, replace it, redo it, whatever. It's not that easy, and it has ramifications. And I'm not going to go through all of those, but I've highlighted a few that are reasons why we want to do it right, and you want to do it properly to help instill confidence in the public, let everybody know that you folks are smarter than everybody else in the government world, and you know the rules, you're willing to follow them and make a legally defensible decision. So there's potential exposure to the city, and I say exposure because ultimately what that means is your decision, if a mistake is made, could be invalidated by a court. And that means that all the time and work and energy that went into it goes down the toilet, you gotta redo it. It's embarrassing, it's bad media exposure, but it means more time and expense and frustration. So the goal here is do it once, do it right, follow the right process and procedure, and that's what I'm going to focus on as we get into this. There's potential individual employee or officer exposure, and unfortunately, Bob, again, being a good practitioner in this area, he's seen it all. The courts have made it very easy to sue individuals in their individual capacities, that is, individual decision makers, when they don't follow the rules and they make a decision that is deemed arbitrary and capricious or doesn't comply with your adopted standards or is a violation of appearance of fairness or one of the other myriad of potential mistakes that are out there. You can get named as a defendant and potentially have personal exposure. These types of lawsuits get ridiculously expensive, and I'm not exaggerating that. I've been involved in land use lawsuits where the other side has accrued over $1 million in attorney's fees. That's the other side, not me. And we've never gone to trial. That was what they had accrued by the time we either had a motion or hearing or something like that. So it's not unusual to see just huge dollar numbers come up for expenses and potential jury verdict if it goes to trial. And I'm going to highlight a couple or mention a couple of cases to you. We'll get into this where land use mistakes were made, examples where elected officials kind of started meddling in the province of staff and trying to dictate how staff should make decisions or what types of evidence staff should consider at an initial hearing, and they got sued for that and lost, and the damages are in millions and millions of dollars. The city of SeaTac recently lost a big land use case, a big one, to the tune of about $12 million. And it was reported in the news media. I'm not disclosing anything out of context, and they thought they had a good defensible case. That's $12 million. So anyway, there's a lot at risk, and we're going to try to do everything we can to show you how to avoid those risks and make the right decision. So let's start off and kind of talk just about the big picture, what the environment is for what constrains decision making. Again, whether you're a planning commissioner, city council member, and the different types of decisions you're making, there are legal constraints on what you can do. And they start off with constitutions. I put that plural. There's state and federal constitutions governing, particularly 5th Amendment, 14th Amendment of the U.S. Constitution, put limits, due process, regulatory takings, things like that. There are a plethora of statutes, a lot of state statutes, GMA, Growth Management Act, SEPA, the State Environmental Policy Act. There's the Regulatory Reform Act. I'm going to talk about a number of these, but they provide constraints on your decision-making authority also. Your comprehensive plan and adopted updates provide kind of an overview of their, kind of the limits on your decision-making, particularly in the planning stages, and particularly for planning commissioners and then council members when you're acting in a legislative capacity to do updates and plan, do your long-term or long-range visioning for the city. City ordinances and resolutions, got a lot of those. I'm not an expert in your code. You have one here. Bob's sitting over there, and he can chime in throughout this and maybe give you some examples of where your code provides specific standards or criteria to follow for particular types of decision making. Prior permit decisions and development agreements, very important because they provide, again, an overview and put constraints on decision making for projects that are done either through a development agreement, which they're becoming very, very popular. A lot of cities use them. They're great, but the bottom line is you got to follow them, you got to comply with them, and you can't revise those or ignore the requirements in those development agreements. Once they've been approved legislatively, they're applicable to specific properties or projects, and they govern those, and particularly prior permit decisions. This kicks in when you have, for example, planned unit developments or multi-stage developments or kind of multi-use projects that are handled in different stages at different times, and like master use agreements, things like that, that will make an initial decision on a project or a piece of property that's the project's done in phases. Subsequent phases need to comply with those decisions. And you don't comply with them, you're running the risk of a lawsuit. Court decisions, lots of those out there. I'll give you some examples of just some bad cases, primarily to tell you what not to do. And then board, agency, administrative decisions, things like that can also govern and constrain your decision-making authority. So let me start off kind of after that little primer on the legal environment and talk to you about what's high risk. What are we watching out for, and why are we concerned about these types of permits? Well, there are a number of particular types of permits, and unfortunately I apologize, I noticed I cut off a couple of the elements at the very bottom there, but I'll tell you what they are. This is a non-exclusive list. Bob and I were talking earlier today, and I was kind of going through this PowerPoint, and I said, geez, again, all these high-risk land use actions, I could have done 10 slides on these. And he goes, yeah, I know, but you got to cut it down. We only have so much time. So I tried to whittle down some of the really important high-risk types of actions. Unfortunately, most of these are cases I've been involved in. In other words, I've seen lawsuits arising out of things like moratoria, which are authorized, and I'm going to mention at the very end of the session here, but they're frequently not used properly, or people forget about them, or they let them go on forever and ever and run the risk of violating state statutes. So they can be high risk in that regard, but a variety of other types of projects, like a moratorium, you can adopt through an ordinance. Sorry, that's my using the plural, I guess. I hope I'm right on that. But it's a moratorium, basically, to kind of stop, put a hold on development applications for a period of time. Things like adult entertainment facilities, gambling regulations, sign regulations, very controversial. Every time I go to, and I think Bob attends these seminars by the State Association of Municipal Attorneys, there's some session on updates on sign regulation law. It's gotten very difficult to regulate signage now. You could spend a day just talking about that, even though lawyers can't figure out. There's a recent case came down about a year and a half ago, Reed versus Town of Gilbert, that just added all sorts of new kind of issues and problems to government authority to regulate. Large, complicated developments, and I note I put them there with tight timelines by developers. And I mention this specifically because it's something to watch out for. I've seen in my practice, and other practitioners I think will concur, that when you get a project in and it's a large project, either in size, scope, or impact to a community, and the developer is pushing for fast decision making, shortened time frames, or telling you we need decisions really fast, those are red flags. And I always tell cities I'm doing work for to step back and not rush through projects like that, even though you may be getting pressure from the developer. That's just a recipe for a lawsuit. It's a recipe for a mistake, more important. Okay? Malls, strip malls, large, complicated, big dollar commercial projects, ignoring vested rights, large, controversial, or politically sensitive projects like shopping centers, strip malls, large subdivisions, environmentally sensitive projects. Those are all, again, high-risk types of land use actions and decisions that are ones you need to watch out for and make sure, A, you're following the right process, and B, you're applying the right substantive rules, which we're going to talk about here today. A few others, and as I said, I whittled about 7 slides down to 2 here, and it was tough to do that, but things like impact fees, public nuisances, affordable housing is a hot button right now all over the state with zoning regulations and not complying with adopted standards, things like that. Citing and regulation of tent cities. I've defended 4 of those lawsuits already. They just keep coming. Group homes, historic regulation. You folks have a beautiful historic zone. Those can be problematic frequently because sometimes, and I'm not talking about yours, but other cities, the standards are vague, they're ambiguous, they're not well defined, and they cause problems, or they provide too much unbridled discretion to the decision maker, which causes problems. And so there's potential risk there. Regulation and zoning of cell towers, and a lot of those are preempted by federal law. The regulation of essential public facilities, the big controversial things, and other unique, complicated projects. And I'll tell you real quickly, the things I watch out for when I get a call, and it's usually after the damage is done, but I'll get a call from either WCIA or from a city saying, gee, Mike, we need help, we got a problem, we got a lawsuit filed against us, and I can almost always identify what the background is without even knowing about it. I usually say, well, let me guess, it's quasi-judicial, right? Yeah, I didn't know that. Well, I've been through a few of these. Probably a decision by the elected official, by city council, right? Yeah, it was. Probably a big dollar project at issue, right? Yeah, it is. And I can go through, and I got a list of about 5 criteria, and about 90% of the lawsuits that I've had to defend, land use lawsuits of the last 25 plus years, have those criteria on them. It's just almost predictable. So you're going to see that throughout my presentation tonight, I'm focusing on a lot of those things. I'm going to be talking about quasi-judicial decision making. I'm going to be talking about arbitrary and capricious decision making, which is a standard of liability. I'm going to be talking about the different roles that the decision makers, planning commission versus council versus staff have. And I can tell you that's, I can focus in on where the risk is, and that's what I'm going to try to focus in on tonight, because again, the goal is to make a legally defensible and proper land use decision so that you avoid all the parade of horribles that I've had to see in some of my practice. All right, so I've got a few tips here. I'm going to kind of skip through these fairly quickly, but you folks have available to you a copy of the PowerPoint. You're welcome to refer back to it. And you're going to hear me kind of talk about a couple of points throughout this presentation. I go, God, he said that 3 times already. Well, there's a reason I'm saying that 3 times, because it's really important. And the first thing I'm going to say in almost every one of these topics I'm talking about is know and follow your code and the state law. I cannot emphasize that enough. Literally, probably 75% or more of the cases I've had to defend or problems I have seen with land use decision making is where the decision maker has ignored or bypassed or superseded or expanded on what's allowed by their code. Okay? So the starting point for any decision that you're going to make, particularly quasi-judicial, is, and I always, kind of instruct clients to look at things this way, is when you have an application in front of you, whether you're planning commission, even whether you're staff, and whether you're city council, even a hearing examiner, the first thing you do is take a look at the type of application that's before you. Is it a plat? Is it a site plan? Is it a conditional use permit? Is it a variance application? Is it a waiver, critical areas exemption, something like that? Figure out what the application is. That shouldn't be too hard. And then go to your code and look up the standards that apply to that specific type of application. That should be the starting point for any quasi-judicial analysis, okay? And that's why I mentioned this up front, and I'll be talking about it again and again, because it's really, really crucial. And there are legions of cases that I can talk about, that Cox versus Linwood, where the city tried to impose short plat standards on a boundary line adjustment. They just literally said, well, this is an application for boundary line adjustment, but it kind of looks like they're trying to short plat the property, so we're going to require them to comply with our short plat standards. And guess what? You can't do that. The applications for boundary line adjustment, you look at the BLA standards in your code, or if they're not your code, any other standards that may be applicable through state law, and that's what you apply. And you don't try to second guess the applicant or apply different or unrelated standards. And that's just a crucial problem that just will inevitably lead to a lawsuit and an invalidated decision. Don't meddle in staff's process. It's a huge problem throughout, every city I've ever done work for. And I'll be honest with you, it gets down to one of the other themes you're going to hear me talk about, and that is that elected officials should, to the extent possible, defer and transfer their decision-making on quasi-judicial matters, should defer that to, or transfer that to a hearing examiner. And I'm a huge proponent of hearing examiners. I'm going to talk about that a little bit later tonight, why I think they are great process decision makers for cities. Almost every city is expanding to use hearing examiners. I'm going to talk about one more, but using a hearing examiner avoids a lot of the problems that are listed up here, the tips, and avoids arbitrary and capricious decision making on a whole bunch of levels. I know the city of Snoqualmie uses a hearing examiner. I'm not an expert on the rules. I did look under, I think, chapter 2.14, and that's great. I'm elated to see that, and I will tell you that, from an outside perspective, that's good. But I think you could probably use it to a greater extent too. Again, but I'm not here to tell you how to change your code, but I'm here to suggest maybe some ideas to help things run more efficiently, help you make better decisions, and help avoid risk. All right, so hire competent staff, and I think you've got good staff. I don't know everybody here, but I've worked with some of the folks. You got a great city attorney. I've known Bob forever, and I'm mentioning that not to pat him on the back, but to say he's a good resource. And there are a lot of cities I do work for that their city attorney has never done any kind of land use work. They don't know it. And believe me, I'm working with a couple right now. They're calling me all the time. Bob's a whole different kind of skill set there, because he's done a lot of this for Federal Way and Mercer Island. I've worked with him in all these cities, and when he was with Kenyon Deason, and so he's got a lot of good experience, and I mention that because he's a good resource to draw upon. All right, so first step in this big process that I'm talking about here is, what type of decision are you making? Okay, and this really gets back to the kind of big rule of make sure you're applying the right standards to the right application, and you're following the right process for the particular type of decision you're going to make. There are three primary types of decisions that cities and government, local government can make. They're either classified as legislative, quasi-judicial, or ministerial, or sometimes called administrative, same thing. I'm going to be focusing tonight on the quasi-judicial. It is the highest risk type of decision. It's the most complicated. It is the most fraught with potential errors. And it's the one that really leads to most of the problems. And so we're going to talk about all three of these, but I wanted you to know that you've got three different types. And the ministerial is not, well, let me go film real quickly here. I'm just going to give you a quick overview. So legislative decision making is the lawmaking. Okay? That's what the elected officials do. Frequently with input from planning commissioners who make recommendations on things like comp plans, etc. And I'll give you some examples of this in just a minute. But it's the lawmaking end of this. This is just like the three branches of government at the federal level. It's kind of the same thing at the local level. So elected officials can act in a legislative capacity. And we'll give you some examples of that. Quasi-judicial is the one that is the kind of important types of decision. It literally means acting like a judge. When you make a quasi-judicial land use decision, you are literally held to the same standards a trial court, federal or state trial court judge is held to. You got to do what they do, basically follow the same kind of procedural due process rules, follow the same standards, and you're held literally to the same standards as a judge. Okay? And believe me, I've had to defend this in court when challenges have been made to quasi-judicial land use decisions, and the other side, that's the first thing they pop out of their mouth when they go into court. Your Honor, the city council here thinks that it's just they're all lay people, and that's their complaint here, and they say that gives them a free pass. Well, it doesn't, because the law says they're obligated to follow the same process, the same standards as a trial court judge, and that's true. All the cases say that. So it's important, and that's what we're going to be focusing on. Ministerial or administrative type decisions are, on kind of smaller permits that don't have a hearing associated with them, things like building permits and grading permits and tree cutting permits, where simply they're usually resolved at the staff level, and it's the building permit is kind of a classic example. Somebody comes in and applies for a building permit. The building official takes that, goes through, compares what's on the application, make sure all the forms, the blanks are filled in, the information's provided, everything's there, then compares that to the standards in your code. And those standards may simply be the UBC or the IBC, the International Building Code. There may be some, some other criteria, but the bottom line is the city staff has got to follow those rules and simply compare the application to that, to those rules. Question. Yes.
I didn't realize this was going to be such an emotional moment.
Sorry about that. It choked me up, and I knew you were going to ask me a hard question, so I got choked up.
Yeah.
Okay.
So quasi-judicial, so the legislative is making the law.
Right.
Quasi-judicial is taking an application and applying the law to it. So they're judging it according to the law that the city council is putting in place.
Exactly. With the addition of a hearing process that's also associated with that. But you're correct, yes. And that's what differentiates quasi-judicial from ministerial and administrative.
So it seems to me at the federal level, these are all separate. But now you're at the legislative branch at a city level also has the judicial responsibility as well.
Well, the judicial is the quasi-judicial. That would be the analogy to the federal, anybody that, looks at the federal law, the breakdown of federal decision-making, you've got the legislative branch, the judicial branch, and the executive branch. The ministerial would be somewhat associated with the executive branch. It's kind of an executive administrative decision-making. The quasi-judicial would be, it's not a direct analogy, but it's closely akin to like a judge.
But apparently we don't get to be quasi-judges if we have to be real judges.
Well, that's right. And quasi simply means you're acting like a judge would act, even though you're not labeled judge. You're labeled a city council member, for example. Or in the case of a planning commission, that's handling a quasi-judicial matter, they would be acting like a judge also. Again, held to the kind of the same judge standards. You're asking a good question, and note, by the way, your code, I again didn't go through it in detail, but your code allows or provides that both the planning commission and the city council can, depending on the situation, act in a legislative capacity as well as a quasi-judicial capacity, but not at the same time, okay? So there may be certain things that you as a city council do that are quasi-judicial, and others like adopting a comp plan, revising your code, changing standards, things like that are legislative. But the point is, Washington law is a little bit unique in this respect in that state law allows local governments like the city of Snoqualmie and others to have their elected officials act in both these capacities. Okay? A lot of states don't allow that. Washington does, but it's optional. In other words, you don't have to, the city council doesn't have to take on the role of quasi-judicial decision maker. You can assign that to a hearing examiner, one way around that, or you can retain that authority or some piece of that authority. I'm going to talk about that a little bit later too. And maybe I'll flush this out a little bit more. If you're still confused, let me know and I'll better confuse you.
As long as emotionally you can handle it.
I can handle it. I'll stop choking. I got my water down. I should be good. All right. So let me flush this out a little bit more. Legislative decision making. It's the policy decision making. This is the things like. Let's go to the next slide. Here's what it is. It declares or prescribes a new law, policy, or plan. Okay. So that is the definition from this case. I actually was involved in a piece of this Phoenix development case. It was a damage claim that got dismissed on this case, but that case defined legislative action in this way, and it's a pretty accurate definition. Prescribing a new general application law, meaning it applies throughout the city, or new policy or new plan. And so here are some examples. This may flush it out a little bit more for you. So it's policy making, it's things like making decisions on capital improvements, comprehensive plans, area-wide planning, adoption of zoning maps, adoption of GMA development regs, general application ordinances, general long-term planning decisions, infrastructure, annexation, quintessential legislative action, contracts, and things like interlocal agreements. Those are examples of acting in a legislative capacity. Okay? So it's the lawmaking. And one of the reasons why this type of decision making is not as high risk or problem infused as quasi-judicial, there's a number of reasons for that. But first and foremost is the courts have given a great deal of additional deference to elected officials when they're making legislative decisions. They don't want to interfere with the lawmaking policy